Ladies and gentlemen, we're going to start this off.
Relax, calm down now. Don't stress. Take it easy.
Okay, we're going to have a good day and a good meeting. Want to thank everybody for being here today and being concerned about your community. We're going to open this meeting up. This is a 5:01. We're actually 5 minutes late, so it's 5:06. Public hearing in Citrus County Board of County Commissioners to conduct a public hearing and land application CPA-AA-PUD-14-26. Clark A. Stillwell, Esquire, for Halls River Development, Inc. After they conduct of the public hearing, the Commission will be asked to take a final action on the land application, either by approval or denial of the application. To make all aware, the formal party to this proceeding is Halls River Development, Inc., represented by Clark Stillwell, Esquire, and the county, who will represent or who will present a staff presentation and recommendations. A formal party to the proceedings in accordance with the law. And as a matter of procedural. Hang on, put my glasses on. We'll get this right. Procedural due process has the right to cross-examine witnesses, present evidence, and demand what witnesses testify under oath. Although the public is not a formal party to the proceeding and as such does not have a right to cross-examine witnesses and demand the witness testify under oath. The public does have the right to be heard, and opportunity will be given to the public to be heard. To ensure that everything runs smoothly, I find it important to quickly go over the procedure of how things are going to occur for this hearing. Prior to starting, I will go through the procedural housekeeping matters. The county staff will make their presentation as they do in all land use proceedings before our commission. Then the applicant, Halls River Development, Inc., will have an opportunity to make its case. After that, the board will open it up to the public. Once the public portion is closed, the applicant will have an opportunity to make a brief rebuttal. Then I will open it up to board for discussion and action. If any person decides to appeal any decision by the board with respect to any matter considered at this hearing, he or she will need a record of the proceedings, and for such purpose, he or she may need to ensure that a verbatim record of the proceedings is made, which record includes testimony and evidence upon which the appeal is to be based. During the public portion of this hearing, proponents and opponents' comments will be limited to 3 minutes for individuals and 5 minutes for organizations. You will not be given more than one opportunity to speak before the board. When anyone wishes to speak, come to the podium. They must print their name and address on the green slip, which is over here, it should be, and hand it to the clerk, which is over here, and sign it. Please state your name and address on the tape record, which is in the microphone. The issue before us today is whether to allow for a proposed amendment to the generalized future land use map of the Citrus County Comprehensive Plan and to amend the land use atlas map of the Land Development Code to establish a plan unit development. When anyone comes up to speak, personal attacks on another individual will be considered out of order, and you will be asked to leave the podium. Additionally, when you come up, this is a time for you to comment, and your comments need to be addressed to the chair. This may be a long proceeding, and as such, the board may, at its own direction, take recesses as needed. If and when recesses are called, do not speak of this issue with the board members. The board retains the right to ask questions at any time of anyone. Any witnesses that may speak today will be placed under oath if questioned by applicant, and you are subject to cross-examination by the applicant. First, the board needs to formally adopt backup materials into evidence. Commission motion and second, and a vote, no public comment. Prior to proceedings, I'm going to defer to the county attorney's office for ex parte communications, and then take care of procedural matters. County attorney's office asks the board members to disclose on the record any ex parte communications with regards to the application before the board.
Okay, Mr. Chair.
Is that good? Man, you could have made that shorter.
Good job, Mr. Chair. First, we need the board to formally adopt the backup materials into evidence, Mr. Chair, so you should.
Mr. Chairman, I'll move approval of that item.
Second.
We have a motion and a second. And now
There's no public input on that.
we'll call the vote. All those in favor?
Aye.
All right, so all of your backup materials are now part of the record. And next, I'm going to ask regarding ex parte communications, and I'll start with Commissioner Meek. Have you had any ex parte communications on this matter?
Madam Attorney, only from what I have seen in the public record, general discussion in the community, but nothing specific. No, ma'am.
Thank you. Commissioner Kitchen?
Yes, ma'am. A couple of things. One is received all the emails, I believe, that most of the commissioners have, those types of things. I did have a
Town hall?
I did have a town hall, and at the town hall, folks wished to address that issue, and at that time, I told them that I could not speak about it. Some folks wanted to address their positions on it, and I told them I could not comment on it. Also, I was asked to speak at the Sugar Mill Woods Civic Association, and I actually had a person ask me a particular question that said, how do you think the board will vote? And my answer was, I don't know, because I don't even know how I will vote. So those are my two outside ex parte communications outside of this venue. So.
Any site visits, too, might be included in that if anyone took those?
Yes, I did drive by the site and look at the site personally.
Thank you. And Chairman Adams?
No, ma'am, I haven't talked to anybody except a bunch of fine people I welcomed in when they came in, but we did not discuss that, and I've lived here my whole life, so I've passed that site many times in my lifetime.
Thank you. Commissioner Carnahan?
I have read emails. I have spoken to the Citrus County Council. I let them know right off the bat when the question was asked that I could not.
Your microphone.
Let me back up again. I have received emails. I have spoke with the Citrus County Council on Wednesday. The question was asked. I let them know real fast that I could not disclose where I am on this position. And with that, we had a few comments from the public. Also spoke to the United Methodist Church, the women's group in Homosassa. The question also arose, and I let them know real fast that I didn't want to speak about it, my position on this, because it was an upcoming item that we had to deal with. I have been by the site numerous times by living here all my life, and that'd be it.
Thank you. And Commissioner D'Amato?
Thank you. Read the emails, read the letters. I've seen articles in the newspaper. And 40 years ago, this June 22nd, I was married in the Quonset hut at Nature's Campground, which is an adjacent piece of property to that. So I am familiar with the property. I visited the property. Mr. Lenz owns it in the 1970s. I visited the property before the last land use change before the board, and also back in the 70s, the Homosassa Springs Chamber of Commerce also held its annual barbecues on said subject property. So yes, I am familiar with the property.
And I have an opinion from the Ethics Commission, and I have no conflict of vote due to a issue I'd like to put into the clerk of record.
Okay?
Only because Mr. Stillwell represents a company of mine, so I had an opinion given. I'm a 20% owner, minority stockholder, so to make sure that we were legal and doing nothing wrong, we had an opinion, and it said no problem.
That doesn't have anything to do with this particular land use. That's with your representation with the applicant's attorney.
Correct. But I didn't want any misconception of anything
Right.
for any of us.
Thank you, Mr. Chair. And based upon the disclosures by the commissioners, it might be appropriate this time to ask the applicant if he would like to inquire of any of the commissioners about their ex parte communications that they've disclosed. Thank you.
Mr. Stillwell said no.
And I'm sure the record will reflect that Mr. Stillwell said no on behalf of his client. The only other procedural matter that I would like to address is the reading of the ordinance, Mr. Chair, and I can do that whenever you're ready, or whether you would rather read through the rest of your procedural notes.
Well, should we go ahead and get one now?
Put it on the record.
Okay. Let me-
Read it.
Do you want to, you go ahead.
I'll read it for you,
Okay.
sir.
Yeah.
Thank you. Okay, as this application proceeds, you'll be asked at the end of this public hearing to consider two ordinances, and at this time, I'll read those ordinances title into the record. The first ordinance would be an ordinance of Citrus County, a political subdivision of the state of Florida, amending Citrus County future land use map by redesignating approximately 7.18 acres from recreational district and approximately 2.55 acres from Coastal Lake Commercial District and approximately 1.27 acres from Low-Intensity Coastal and Lakes District to approximately 6.13 acres to Coastal Lake Commercial and 4.57 acres to Low-Intensity Coastal and Lakes, providing for severability, providing for codification, inclusion and scrivener's errors, modifications that may arise from consideration of public hearing, and providing for an effective date. And I'm going to go ahead and apologize to the court reporter for reading too fast. The next ordinance you'll be asked to consider is an ordinance of Citrus County, a political subdivision of the state of Florida, amending the Citrus County Land Use Atlas Map by redesignating approximately 7.18 acres from recreational with a planned development overlay and approximately 2.55 acres from Coastal Lake Commercial with a planned development overlay and 1.27 acres from low-intensity coastal and lakes with a planned development overlay to approximately 6.13 acres coastal lakes commercial with a planned unit development and 4.57 acres low-intensity coastal and lakes with a planned unit development, providing for applicability, providing for modifications that may arise from consideration at public hearing, providing for severability, and providing for an effective date. You're continuing on it. Now I will turn to.
Now I will turn to procedural matters. If a formal party to the proceedings makes an objection, anyone who is speaking at the time must stop and wait for the objection to either be sustained or overruled. In a moment, I will give an opportunity for the applicant to take care of any procedural concerns they may have. Do any of the board members have any procedural questions or comments? Does the applicant have procedural matters to resolve now? Do the board members have any
No,
comments?
sir, Mr. Chairman.
The applicant, Mr. Stillwell, would you like to address anything?
Thank you, Mr. Chairman. On behalf of everyone here, could we have the air conditioning turned on, please?
We ask that every time.
I think they get mad at us, so staff turns it up or turns it down.
The procedures are fine. Initially, we simply would like to ask after the staff report, a few issues on cross-examination. Thank you.
Thank you, Mr. Stillwell. All right. We will now proceed with the hearing. Okay. We'll conduct a public hearing to consider the application CPA-AA-PUD-14-26. The county presentation shall take place now. Ms.
Good evening, Commissioners. This is an application to amend the future land use map and also the Land Development Code Atlas. I'm going to go through a PowerPoint as I talk. I think it's easier to look at pictures as we do talk about this. This site is located on West Halls River Road in Homosassa. There's an aerial view of it. You can see that it is vacant and unimproved, although there are some trails, some remnants of maybe some old concrete trail there, a couple piers. This is the current Land Development Code Atlas. It is made up of 3 different land uses: coastal lakes, commercial, recreation, and CL, which is low-intensity coastal and lakes. They all have a plan unit development on there that was approved in 2011, and I'm going to talk about that in a moment. But what's being proposed here is to remove the recreational land use district and instead distribute that land use into the coastal lakes, commercial, and coastal lakes area. So the recreation consists of approximately 7.18 acres, and the coastal lakes commercial right now is 2.55. Coastal lakes is 1.27. The coastal lakes, or CL, would go from 1.27 to 4.57 acres if this application is approved. The CLC district would go from 2.55 acres to 6.13 acres, and all of them will still have the planned unit development, which is the master plan in place. You can see the red on the back, that's RVP, or that's Nature's Resort RV Park. It does wrap around this site. Across the street, the purple is Coastal Lakes Commercial. That's the Margarita Grill site. And you'll also see some Coastal Lakes Residential, which is across the street. There's some individual homes at that site. This is across the street, Margarita Grill. The area on the left is part of the wetlands that's proposed to remain on this application. This is an existing dock there. They are proposing to keep this existing dock. The boat ramp in the bottom of the picture is proposed for removal. It's not on the master plan. This is also an existing dock that is not on the master plan. It is falling apart. I guess they're going to remove that. You can see Nature's Resort site just to the top of that picture. And this is an existing canal. It is a man-made canal with some concrete walls on the side of it, and that is proposed for removal as part of this application. Not much to see here. I took a representative sample. There's a lot of trees, a lot of trails, not much out there right now. This is the master plan that was approved in 2011. I did want to talk about this because this particular application that was approved by the Board of County Commissioners in 2011 did approve 31 cabins, a manager's residence, and a 3,000 square foot restaurant. So if this application today is not approved, they do have this right now on the books. This is the approved plan on the site. This is what's proposed. Instead of cabins, they're proposing 1 hotel. It's a 110-unit hotel. The restaurant has reduced in size from 3,000 square feet to 2,500 square feet. You can see the yellow areas of wetlands. Those are proposed to remain. There would be a boardwalk through the wetlands. That's similar to the previous plan. A lot of drainage retention and quite a lot of development there as far as landscaping and buffering. They have demonstrated concurrency on this application. They are meeting that. A few items to bring up. First of all, they're not asking for any deviations from the Land Development Code. Staff did review this in detail with Land Development Code requirements, and they are meeting all requirements of the Land Development Code. As noted, they have sanitary sewer and potable water are being met on this site. There's a lot of public input on this site. Quite a bit of it came in as last-minute additional items that hopefully you all received a copy of. Some of them were emails to you. I'm not going to go through all those, but some of the same things were coming up on many of them that I'm going to talk about very briefly. First of all, this is not in the velocity flood zone. A lot of the public input did say it was. It's not. It is in the flood zone, absolutely. Like most of Halls River Road, it is in a flood zone, but it's in an AE flood zone, not in a velocity zone. There's a lot of comments about traffic concurrency. Citrus County no longer has traffic concurrency. Traffic concurrency was removed from our comprehensive plan years ago. So looking at traffic and whether Halls River Road can handle traffic for this development is not in our comprehensive plan. It's not one of our tools in our box to review this. However, the applicant did prepare a professional study on hurricane evacuation for Halls River Road. It's not required, but it's in your packet from Kimley Horn. That study did show that when this application is fully developed, if this is approved, Halls River Road would still be able to meet hurricane evacuation standards. The Planning and Development Commission did hear this application on February 5th, 2015. They did recommend approval by a 6-0 vote. They have a few conditions that were modified since that time because the applicant has met them. If your indulgence, let me go over those very briefly. I'm going to summarize them, but the conditions I would ask to be part of the record. Number 1, that the plan unit development shall allow for 110 hotel rooms, a restaurant, and hotel ancillary uses as outlined on the master plan, date stamped received March 6, 2015 by the Land Development Division. Construction shall take place in accordance with the criteria and requirements of the Citrus County Land Development Code, including Section 3740, additional design standards for large non-residential projects, unless it's specifically outlined within these conditions or the final development plan. Condition 2, the project must be served by central water and central sewer. Condition 3, the site will provide a minimum 50-foot setback to all water bodies and a minimum 15-foot undisturbed natural buffer to all jurisdictional wetland lines. You can see on the master plan that is being met. Number 4, the site and stormwater management design must meet the requirements of the Citrus County Land Development Code in effect at the time of permitting. Number 5, a biological survey meeting the requirements of the LDC must be submitted and approved at the time of permitting of the site. Number 6, a tree preservation plan must be submitted and approved at the time of permitting of the site. Number 7, all exterior lighting shall be positioned and shielded so as not to illuminate adjacent properties. The next 3 conditions that the planning board had actually have been met. Number 9 talked about the need for auxiliary lanes or turn lanes. The applicant is planning on providing a turn lane that is shown on the master plan. Number 9 talks about the width of the drive aisle. The applicant has amended the site plan to meet minimum aisle width requirements. And number 10 talked about an undisturbed buffer adjacent to all wetlands. That is demonstrated now on the master plan. So the next condition would be condition number 8. Signs proposed on the master plan are required to comply with LDC section 9200 types of signs and sign standards. Number 9, where standards are not specified herein, the Citrus County Land Development Code standards or current code standards will apply. And number 10, minor modifications to this master plan of development may be approved by the Director of the Land Development Division as outlined within section 4304 of the Land Development Code. There is one additional condition that has arisen since the writing of this report. As you may or may not be aware, the FDOT is trying to rebuild the bridge on Halls River Road. Because they're rebuilding the bridge, that may affect the construction of the turn lane on this site. They may have to, it probably will not be a standard turn lane. They're going to have to design it in accordance with the way the bridge is coming. So staff has proposed a condition that the applicant has stated he has no problem with, but we'll make sure that when it comes up, is access on West Halls River Road would be subject to FDOT guidelines and recommendations. Although West Halls River Road is a county roadway, the construction of the bridge is going to impact that turn lane, and they may have to modify it accordingly. Other than that, that's all I have.
Thank you. We will now,
Question?
yes, sir, Commissioner D'Amato.
Thank you, Mr. Chair. On that slide that's up there, upper left corner, is that a pool?
It is a swimming pool for the hotel, yes.
Okay. It's on this. Is it on the previously approved site plan?
Yes.
So we have 2 pools.
A
pool now and a pool
pool then and pool
before.
now, yes.
Okay,
yes.
So we got a pool before and a pool now and a restaurant.
It's not colored pretty, but yeah.
Okay. Pool, restaurant.
Restaurant got a little smaller.
And then the other question is, Is the property in the coastal high hazard zone?
Yes, it is in the coastal high hazard zone. It's not in the velocity zone.
Okay. And then the final question is, the flood elevation, do you know what it is?
Off the top of my head, no. I'm sure I have it on my staff report here.
I know you said it's to clarify some things that were out there. It's not in a high velocity zone, so it's not in a V zone.
Base flood elevation of 9 feet.
9 feet?
Right. They are planning on parking on the lower level.
And that's an A zone?
Yeah, AE.
A elevation 9.
Yes, AE elevation 9 with the new standards,
Thank
yes.
We're going from 33 units, is it, or 31 units to 110?
It was 31 cabins in the manager's residence to 110 hotel rooms, yes.
Mr. Chairman, just to follow up on both commissioners, they are planning, and this might be for the applicant after he does the presentation, to park underneath the facility. It'll be a raised piling facility with how many stories above that?
Right. The applicant has some renderings I think they're going to show you, but what they've told me is it would be one area of parking and then 3 floors above. That is allowed. Our coastal high hazard standards are 4 feet above grade or 50 feet.
Do we have, Mr. Chairman, thank you. Do we have, from a utility operation standpoint, water, sewer, is there any capacity issues? Do we have the capacity?
According to statements the applicants provided, no. I mean, yes, we do have capacity. There's no issues.
Okay.
I'm
good for right now.
Good for right now.
Okay. We will
Mr. Chair,
now.
Mr. Chair.
Yes, ma'am.
If I might, we have some individuals in the overflow room that would like to speak, so when the applicant has completed their presentation, please keep that in mind.
Okay.
We'll have to bring them down.
Do we happen to know how many individuals in the overflow room, officer? 6? Okay. All right. Well, if we could, would the applicant please come forward to make their presentation?
Good evening again. Clark Stillwell, 320 South Highway, 41 Brandon Bank Building, here in Inverness, Florida, on behalf of Halls River Development, the owner of the subject property. Before I get into my presentation, just a brief cross-examination of the staff report, if I may, Mr. Chairman.
Yes, sir.
Ms. Coutu, the hotel use in the coastal lakes commercial area, is it an authorized use?
Yes, a hotel would be allowed in the coastal lakes commercial area.
And under the plan, is the hotel use deemed water dependent or water related?
Not automatically, but this particular site plan certainly could be looked at water related. They're doing some kayaks and some fishing piers, et cetera.
As a water related use under the future land use element, is there a preference given for those type uses?
Yeah, the coastal area does prefer water related or water dependent uses primarily.
The wetland impacts, if any, on this project, are they similar to or identical to the existing site plan?
Although not a wetland expert, looking at the 2 site plans, they do seem very similar, yes.
And are there setbacks from the waterfront and the wetlands met?
Yes, the application meets Land Development Code standards.
Is the hotel use prohibited in the coastal high hazard area?
Absolutely not, no.
And I know you spoke to this, but what is the height restriction in the coastal high hazard area?
It's 4 stories above finished grade, not to exceed 50 feet.
And in this particular case, does the applicant meet that standard?
From the items that have been submitted, yes. They would be expected to. They're not asking for deviation.
The area is deemed car sensitive per the plan, is that not correct?
Yes.
Does the car sensitive area prohibit this type of use?
No, it doesn't. You have different construction standards that are encouraged, but they're not prohibited.
Did the engineer's report on drainage and cars meet the standards of the Land Development Code?
You have an engineer's report in the information provided that states that it qualifies for karst development.
Were you able to calculate the acreage of the surrounding land uses relative to this site?
Yeah, as best I could. It looks like predominantly RV park. There are some residential parcels and some conservation, but the majority is RV park.
Is that a commercial use?
Yes, RV park is a commercial use. It's stated as that in the comprehensive plan.
Thank you. Thank you, Mr. Chairman.
Yes, sir.
Do you want this, sir?
Yeah, please.
Mr. Stillwell, if you don't mind, can I ask Ms. Kuto something there? In this request, are we depleting wetlands lesser than what the original use was with the 33 units? How much was changed on wetlands?
Right, that's what he was asking me. I'm not a wetland expert, but looking at the two plans, it does not appear that there's any more wetland impact on this new plan than there was on the one that's in existence at the moment. There is a small wetland in the center that they're impacting, but most of the majority of the wetlands on the site are remaining and being preserved.
And in fact, they have what's called a conservation label placed upon them, do they not?
Yes.
All right, let's run, Commissioners, I have a PowerPoint here. It is in your backup. I am not going to go through every slide because I know that you've read it. I'm going to give you the benefit of the doubt. I will stop and speak to some of them, but, and then I'm going to go strictly to the issues. And I've read all the emails, and they all have a series of issues that keep recurring and recurring and recurring. So I'm going to address those issues, and I think you'll see where we're coming from and why we believe we're consistent with the plan and why we should be approved. First off, I want to give you a brief history on this. I'm not going to go all the way back to the 90s, but early in this decade, the 2010 decade, we submitted an application to change it to Coastal Lakes Commercial and Recreation with a PD overlay. That was approved by this board unanimously, if I recall. It was appealed. There were two ordinances adopted at the time. One was a plan amendment and an Atlas amendment, and then one was the PD overlay. The PD overlay was the ordinance that was challenged, and as a result, the plan amendments went legally into effect. From that, we went through a series of court motions, and then I went back in front of the county and requested a master site plan approval under the existing approved land use designations. That was approved. The appeal time ran. We went back in the court and said all of the litigation over the LDC issues, the writ of cert, what lawyers call it, were moot, and the court approved that. And when that was approved, in essence, we ended up with 31 cabins, the restaurant, and the manager's cabin. I'll point out that the 31 cabins are 2-bedroom cabins, so there's 62 bedrooms in this project, not just 31 cabins. So what we've requested is, with the input from the staff, is we've taken the rec district, which is a commercial type use, transient use, and downzone that and increase the Coastal Lakes commercial area. The wetland areas, which you'll see on the map, we were requested by staff to designate those coastal lakes and then label them under the master plan conservation as they exist now, and we did that. So we are developing exclusively in the uplands. Now, there is a man-made canal. We own the bottom of it. We intend to fill it. It's not an OFW. It's not part of the OFW rule, and it's our property. So that impact is similar to the existing site plan, and it's approved. And in legal jargon, what we call that is administrative res judicata. That is, we can do it now, and it's not anything new. You may hear a lot about that. So let's start with the PowerPoint real quick.
I'm told that your clicker might not work, so I might have to advance it for you. We're having some technical problems with it.
This is an aerial from way up high. Next one. Closer. You can see in this particular aerial the surrounding commercial use, that is the RV park, for 500 units, which is Nature's Coast. Next one, please. Same site, same type issues. Next one, please. Much closer, you can see the canal here, and you can see the upland areas. Next one, please. All right, this is the wetland survey that has been approved by the Southwest Florida Water Management District. We were asked to survey and count, identify the acreage for each of those 3 yellow areas. We did that. Some of those are currently in the recreational land use area. Some of them are commercial. We were asked to downzone those into coastal lakes, residential, and label them conservation, which we did. Now, there is a small wetland area in the middle, which is impacted. It's isolated. It's less than 1/10 of an acre. Frankly, we don't even need a permit on a regional level to impact that. So those yellow areas exist under the current master site plan as is, and those yellow areas under proposed site plan exist as is. And those are the prime wetlands, and they're not being impacted. You know, a lot of people talk about wetland impacts. There's no prohibition in the plan per se against impacting wetlands. It's a simple test: avoidance, minimization, and mitigation. Here we've avoided as best we can. We certainly have minimized because we're less than 2/10 of an acre. And again, I repeat, these impacts have previously been reviewed by this board and approved by this board. So they can happen whether you approve this or not. Let's go to the next site, please. This kind of shows the land use districts. That's the existing areas. Joanna went through this. Next one, please. Same thing. This shows the 500-foot notice area. We calculated the acreages in abutting this piece. The predominant land use is RVP, which is recreational vehicle park, which is commercial use. The next predominant land use is the conservation area, and then the next predominant land use is residential. So you can hear a lot about this as a residential area, but in fact, if you look at the map and the acreages, it is not. And those figures are within your staff report. Let's go to the next one, please. We went through this. This is what we're asking. Next one, please. This is the existing site plan. Again, you can see that the wetland areas are preserved, and we fill in the existing canal. Not on this one, but on the next one. So this is the site plan. One of the things I saw in the comments that as I read these various emails was that the hotel could not be placed in this location for 110 rooms. Well, if you go to the intersection of I-75 and Bellevue, you'll find this very same hotel there. We took the construction plans from that hotel as approved by the Marion County Planning and Zoning Department in the footprint and superimposed them on top of our survey. And this is what we came up with. That in fact, that footprint for that building can be located in that site in the upland areas without impacts to the surrounding wetland areas. So people get up here and say, this is 110 rooms and it's going to impact beyond that site plan. It's not a fact. We took the construction plans and superimposed them on top. If in fact if that was true, we wouldn't be here. Next slide, please. Color rendition. The parking is more than adequate. You can see the stormwater drainage, which the engineer's report indicates meets your karst standards. And you can see, again, the wetland areas are preserved because this is significant because all I've heard about or read about is the visibility of what this building is going to look like from the road. And you'll see that in the renderings. Next slide, please.
Mr. Chairman?
Yes, sir. Commissioner Meade.
If you can go back to the other side, I just want to confirm, and looking at this, it doesn't look like there is parking underneath the facility. Is there parking underneath the facility?
Well, you can see the driveways pointing in and out.
I'm sorry. Okay.
Okay.
You'll access them from the
Right.
side? Okay. Thank you.
I'm sure you've read this. I'm not going to read it to you. Let's go ahead. This again talks about plan consistency, certain policies we cited to. Let's move forward. Again, plan consistency stuff. This is in the staff report. Next slide, please. This is the concurrency issues, traffic, stormwater, utilities, solid waste. Utilities and solid waste are straightforward. There's capacity letters in the application. Stormwater, again, we have the engineer's report that says we meet the LDC standards. And as you know, traffic concurrency doesn't exist in Citrus County. I'll talk about hurricane evacuation just briefly. The statute says hurricane evacuation standards apply to residents. The folks that stay in this hotel, they're transient. They're outside the framework of the statute. That being said, we still did an evacuation study, and the professional engineer's report indicates we meet hurricane evacuation standards. Let's go forward. It's Coastal Lakes Commercial. It talks about water-related and water-dependent uses. There's an objective policy in the plan that says they should be given priority. Joanna testified to that issue just a few minutes ago. Next one, please. Thank you. Standard policies about diversity of commercial uses in the county. Next one, please. This one, again, 1716.5 talks to specialized commercial needs such as water-dependent and water-related uses. There's a citation to the Catherine's Bay case in the background material. Catherine's Bay is right around the corner. It's a decision out of the first DCA several years ago. First DCA, in essence, found 3 appellate judges, okay, that these specialized policies that deal with water-dependent and water-related uses took priority over the generalized statements about staying away from environmentally protective or environmentally sensitive lands. So let's go on from there. This is a wetland, again, water-dependent. Moving forward, I'm trying to be brief here, Commissioners. Conservation element talks about standards. We meet these. Let's go forward. Wetlands. Notice there is it's not a per se prohibition here. It doesn't say no wetland impacts. It says you go through the same test that you do with the state: avoidance, minimization, and then mitigation. And your staff report on that issue is entitled to great weight. I repeat, the wetlands situation is the same in the existing site plan, so there's no change to that, and we consider that on this issue res judicata, that is binding on all. Next one, please. This talks about tourism. I don't have to tell you about tourism in Citrus County. It's big, it's bigger, and it's going to get bigger. The reason we're here, and there's an option agreement we provided to the county in the backup, and the reason we're here is folks want to enjoy the river. Tourists want to be on the river. They don't want to be on US 19. And hence the demand for this type of facility. You're only going to find very few 11-acre parcels on the river. You're going to find very few parcels, if not the only one, which has significant or sufficient uplands to support this type of use. Next one, please. More about tourism. You all know this. I'm not going to read it to you. Next one, please. The traffic data, there it is. You can see the increase is 52 p.m. trips, a 90-10 split. We still meet concurrency if it exists, and we meet coastal high hazard evacuation. Next one, please. This is a summary: de minimis impact, recreational waterfront uses, customary uses. We meet the LDC criteria, and the master plan and the conditions ensure that we will meet those. Next one, please. All right. This is a 3D rendering done by Paul Gibbs of the site plan in relationship to the on-site vegetation. And the reason we put this in here is because, as you can see, the subject facility is well set back off of the road. The existing elevation of the trees in those wetlands, they're mature, they're somewhere between 35 to 50 feet. The building itself is 50 feet or less. So, and you'll see in the next set of slides how that impacts visibility. Next one, please. Here's the entrance. You can see the preserved wetlands. You can see the building in the back set back and the style of the building. I'll call it old home commercial. I don't know what you call it. Key West, something like that. But next one, please. Series of slides, again, showing the impact of these wetland areas being preserved on visibility of this building from on and off the road. Next one, please. There's the building in the back. Top left is the internal site view from the hotel looking across the drainage pond. 2 slides showing a waterfront view. Again, 3D slides done with the exact building height and the exact height of the trees. And then the bottom one is a repeat of the area plan showing, again, that the structure is well set back. Next one, please. I'm not going to read this to you. You can read it. We believe there's no issue with compatibility. The areas around it are all predominantly commercial in nature, and we're putting a commercial use there. The ISR in this particular project, the ISR in Coastal Lakes Commercial is 0.35. The ISR in the prior project was 0.245. The ISR in this project is 0.235. So we've reduced the ISR, which means we've reduced the amount of paving, and we've reduced the drainage slightly. I will point out that in the staff conditions, just like with the other approved plan, we commit to best management practices on stormwater drainage. And Joanna can tell you what that means, but in essence, it means that you try to use the most recent technology to treat stormwater and deal with it appropriately. Next one, please. This is what we asked for. Next one, please. That's the staff report. Again, your staff report is entitled "The Great Weight is a Matter of Law." We accept the conditions. They mitigate any potential impacts, if any. Next one, please. Now, this is the issues, and this is what I want to get to, and I'm going to blow through these. Coastal high hazard area, we talked about it. We did a study. We meet the development standards. The use is not permitted. And if someone says to you, this is in the coastal high hazard area, my response is, yes, it is, but it's not prohibited, and we meet the standards. You set these standards in your code. You expect people to meet them. Once they meet them, then they should be allowed to proceed. Outstanding Florida waterway, you're going to hear a lot about this. I assume the OFW rule does not include canals and creeks. That means anything below the mean high water line is not an impact. There's no impact to wetlands, and the canal is a water body privately owned, and we will fill it under standard DEP tests for water bodies. I would point out again that this has previously been approved by this board. Next one, please. Hurricane evacuation. Again, these are transient, not residents. The statute applies to residents, not transients. But notwithstanding that, our study shows we meet the test. Utilities, we heard a lot about this in 2011 and 2012. The county amended any text in its plan to relative to DEP grants and any inconsistency. Manatee Protection Plan, we've only got one dock and one visibility dock. The current Manatee Protection Plan allows one dock per 100 feet, which means that we're going to give up a significant amount of docks if we so desired, and the existing boat ramp is filled. Next one, please. Environmentally sensitive areas. Again, this board, I think, last year heard the Catherine's Bay case, LDC master site plan case, and we heard all about that it was in an environmentally sensitive area. The First District Court of Appeals heard arguments on this in 2010 on that adjacent commercial use, and they basically said, look, we recognize that this is a regionally environmentally sensitive area, But there are areas where you can develop in that regional environmentally sensitive area. And in fact, that application, notwithstanding the wetlands, notwithstanding coastal high hazard, notwithstanding floodplain, met each one of the LDC standards, and the first DCA, rarity, reversed the hearing officer's decision and granted Catherine's Bay its plan amendment, finding it was consistent. And again, they went back to the issue of these generalized plan policies that are in the future land use element that are in the very beginning are tempered by the more site-specific policies, particularly the water-dependent, water-related uses, and the priority for that. Next one, please. And this is just a quote from that decision. And it says, the fact that there are limitations in the area is not a basis to prohibit development, as long as development is carried out in accordance with the plan and the LDC. And your staff report says we do that. Next one. There you are, Commissioners. I hope I was brief. I'll take any questions. Thank you.
Thank you, Mr. Stillwell.
Mr. Chairman, the individuals from the overflow are here in the room now.
Okay, we're fixing to open this up to public, but I want to ask Ms. Kuto one thing. So on our GFLMU, we're going from recreational, 7.18 acres, and CLC, Coastal Lakes Commercial, 2.55, and low intensity Coastal Lakes, 1.7, to Coastal Lakes Commercial, 6.13, and low intensity Coastal Lakes to 4.57. Correct?
Right, the recreation district is being removed and it's distributed in CLC and CL, correct.
Okay. And then on the LUAM, we're basically doing the same thing. We're putting it to the Coastal Lakes Commercial with a plan unit development, 6.13, and low intensity Coastal Lakes with a plan unit, 4.57.
Correct.
All right. We will now open this up to the public. Ladies and gentlemen, there are a lot of you there, and we see everybody. We've gotten a number of emails from folks. So when speaking, we'll go over again. Whoever wants to speak, come up, sign the green card, turn it into the clerk, state your name for the record. Since it's going to be a process, and as I said, we see everybody, so if there's going to be plenty speaking, not everybody has to speak. If, once it gets through, if you send emails, and please do not be repetitious over one another, and I can understand how that can happen because it's your community. But we will now open it up to public input, and we'll...
Are you taking pros or antis
Yeah.
in particular order?
Well, if you're speaking for an organization...
No, I mean...
Pro or con, for or against.
Are you asking for people to speak first who are in favor?
Yes, or again, as a reminder, we should have 3 public representatives.
Or either way, right?
Either way.
Okay.
Either way, right? But it should be first, we'll come with people against it, so we keep it separate, or for it. We'll,
Either one.
or, okay, hang on, Mr. Bitter. Why don't we allow people for it to speak first? And that may be easier because there may be anybody for this. Please come forward. Yeah. All right. So there's nobody speaking in favor, or there is?
Yeah, but
Okay, Bud?
And Mr. Chair, you want to go ahead and ask that 3 times, just to be sure.
Yeah, yeah.
Bud Allen. I live at 1300 Northwest 19th Court in Crystal River, and I'd just like to let the board, or say to the board and county staff that I'm very familiar with the property. I knew it when Charlie Lentz owned it. I was in and out of it during that time, and since Mr. Longacre purchased it, he hired me to go down and remove some homes and cabins that were on the property. County staff at the time in 2001, I think, or 2002, wanted him to get out. One of them was out over the water. I removed it, and I think 7 or 8 cabins that were there. So it's been a multi-use property for years. Even back when Mr. Lance had some mobile homes in there. And I just, it's a good project, and I'd like to see this county or board approve the project for construction. Okay, thank you.
Mr. Allen. Is there anyone else for this project? I see, is there anyone else that wants to speak in favor of this project? I will ask once for anyone else that wants to speak in favor of this project. We'll ask twice. We'll ask 3 times. If there's no one else that wants to speak in favor of this project, now, Mr. Bitter, I would suggest that people that's speaking for groups or professionals come to the beginning of the line, that's speaking in behalf of certain people who oppose it. So professionals and heads of groups would probably work better. If you'll please state your name, sir, turn in your green card.
My name is Rodney McCrae. I live at 10670 West Halls River Road in Homosassa. And I guess I'd consider myself a professional, but that could be argued. No disrespect to the staff. They're very intelligent people. They did a great report. And if I was for this project, it was marvelous. And if I was for it, I'd certainly want Clark behind me. I didn't really know I was going to speak tonight. I was downstairs and thought I could get away from all this, being in a side room watching television. That gentleman over there came and got me and brought me up here, so I felt compelled to have to say something. I'm going to use a phrase that my dad used to use, and he's an old school guy, and some of you probably remember him. Because dare I say what I want to, I might get escorted out of here, so I'll be kind.
We're pretty tough anymore, believe me. We've been through a lot.
Certainly there's a time and there's a place for everything. And certainly this may be the time for something like that, but that place will never be the place for anything like this. And I read somewhere and heard it said that that is a compatible business and a compatible structure for the area. And if anybody thinks that that is compatible with anything around there, as my dad would say, they've got rocks in their head. Real quick, I know there's a lot of people behind me, but I live on that road and I drive past that area at least twice a day. Compatibility has to have something to do with this. Otherwise, it's a done deal and you guys can vote and put it in. But compatibility, as far as I'm concerned, has to have something to do with it. And that's not compatible with anything. If you took all the rooms that were available in Old Homosassa and the rooms that are on Halls River Road, and I think there's 1 or 2 resorts there, they wouldn't total 110 rooms. All the existing rooms in the Old Homosassa area. There's nothing anywhere that is high as that building's going to be. So it's not compatible. It might look good on a beach, but actually the best place it would look is where Clark says one is exactly like it over in Bushnell or somewhere. That'd be a very nice place to put it. Guys, thank you for your time. I respect every one of you. If I knew I was going to come up here, I brought some Cuban cigars with me.
Thank you, Mr. McCray. If the next individual, Mr. Bitter, if you'd please turn in your green card and state your name for the record in the microphone. And are you speaking for who?
My name is Jim Bitter. I am the president currently of the Homosassa River Alliance and resident of Homosassa, but I am speaking for myself. I was so thrilled with this opportunity that I dug deep into my wardrobe and I came up with exactly the same clothes I had wore before this illustrious body a decade ago. In the famous words of Yogi Berra, deja vu all over again. I have, in looking over these plans, there are so many anomalies that are going to be pointed out to you that it's kind of mind-boggling. But one that struck me, and I wasn't really going to go into any of these sorts of details, but ordinarily, when these sorts of developments are being pressed, in order to impress you folks, you hear about all the jobs that are going to be created. But there's not been one word about job creation here. So I'm saying to myself, why didn't lawyer Stillwell say anything about jobs? And then I counted up the number of employees that they tell the county they are going to have. And it comes to somewhere between 10 and 15 employees. They're going to run this massive enterprise with they couldn't even run the restaurant with 15 employees. But why would they minimize the number of employees? Because there ain't no parking. Where are they going to put these folks?
You got 1 minute.
Well, I have already said more than I intended. But when this is all over, there's some deeper problems here within the county than just this particular instance. This never should have gotten this far. The staff, I'm appalled that they could say that this is okay, that they recommend approval. I'm appalled that the PDC was so absolutely ill-informed that they did not ask a single pertinent question. And I want to discuss that further with you folks. I thank you for the time. I believe Ms. Miller has some petitions to present to you, if I may.
Okay. Thank you, Mr. Bitter.
Thank you for the time.
Yes, sir. Would you, ma'am, please turn your green card and then state your name for the record and who you represent, whether it's yourself or the community or...
My name is Ellen Miller. I'm speaking for myself, but I'm also speaking for more than 850 signatures that all these folks signed who are against this proposed plan. It's wrong. It's wrong, as Mr. McCray said. It's wrong, as Mr. Bitter said. One thing that strikes me in every comment that was made by Mr. Stillwell was that perhaps the board that okayed this in 2011 was wrong. Maybe we need to look back to 2002 when, according to the architect's plans, there were 8+ acres of wetlands. Beyond the fact that so many people are against this project, what is wrong with it? The structure is incompatible with the neighborhood. No other structure is 4 stories tall. The proposed development is in the coastal high hazard area and contains acres of wetlands within its 11 acres. How many are wetlands seem to be debatable. This has changed since 2002. The increase of contamination to our outstanding Florida waterways through runoff from the impermeable surfaces would be guaranteed.
Ma'am, could you come over to the mic,
I'm
please?
sorry.
I
I thought I
should have.
talked too loud anyway.
I was hearing you good. My ears was better than I thought.
Number 2, Halls River Road floods and is the only means of access for 8 commercial properties and more than 550 residences. By the way, within the past 5 weeks, the sign "Road Floods" was mysteriously removed from Halls River Road. The roads department knew nothing about the removal and said they would be replacing the sign shortly. The Comprehensive Plan, Chapter 4, Policy 4.9.8, states that all proposed comprehensive plan amendments and new developments within the CHHA must have a 12-hour evacuation to shelter. At the present, the road easily becomes backed up, and in the case of Margarita Grill fire, was blocked for hours. How much more than the 12 hours will it take for the residents, the hotel guests that Mr. Stillwell does not count, and the RV parks to evacuate the narrow 2-lane roads? Number 3, this is the wrong location for a project of this magnitude. The comprehensive plan states that the objectives. 1 minute, is that right? 4.10, the county shall direct population concentrations away from the coastal high hazard area through appropriate regulations in the Land Development Code. And policy 4.10.5, population concentration shall be directed away from the coastal high hazard area. The proposed zoning change is in direct opposition to the intent of the comprehensive plan. Tourism was mentioned too. The tourism is here because of the natural beauty of our area. Water is important. I beg you to reject this plan.
Sir, please state your name for the record, and it looks like you're representing a group, so you will have 5 minutes unless I'm wrong. Correct me.
Thank you. My name is Steve Allison. I'm representing Homosassa River Alliance. I'm from Tampa. Got a green card. I do have a 7-page planning analysis that I need to submit into the record. I don't know whether you want it now or at the end of my presentation. I will also submit a copy of my resume. I know I don't have time to go through 7 pages of this, so I'm going to kind of wing it here and bear with me to the extent possible. I guess I have 3 principal objections to this proposal. One, I find it inconsistent with the comprehensive plan. 2, it is deficient in its compliance with standards of the Land Development Code. And 3, it is grossly incompatible with this area. I want to first hit on the issue of a Land Development Code matter. This particular site plan, particularly in terms of the site data, is filled with errors. We've struggled with coming up with acreages and calculations based upon the data of this plan. It's an impossibility. But the first thing I want to bring up is what's called the impervious surface ratio. They state on this plan that it's 0.218. Mr. Stillwell in his presentation just mentioned that it's 0.235. It seems like we're dealing with new numbers all the time. Neither one of those are correct. And what they ignore is a provision in Section 1500 of the Land Development Code, which defines wetlands, and it provides that at the end of the definition, it says, for purposes of development review under the LDC, wetlands are presumed to be impervious. Consequently, you have to count that into your impervious area ratio. They have not done that. When you do that, and there's some judgment involved as to how you actually make that calculation, we've gone through probably half a dozen iterations of that. All of them exceed the 0.35 that is the maximum allowed in the CLC district. Consequently, on that grounds alone, we find this application to be both deficient and impossible for you to approve. Similarly, again, because wetlands count into the impervious area, the FAR listed on the site plan is erroneous. It's listed at 0.1 something. It's actually 0.246. There are errors in the first one. It was asked earlier, just the most basic of information about what this proposal is from and to, the different acreages, 718 recreational current, 255 CLC, and 127 CL, 613 CLC, and 457 CL. Well, the problem there is it's an 11-acre site, although even that is up to dispute because Exhibit G has a different total acreage figure. But just going with the figures that they have provided and that are repeated in the staff report, when you make that change, when you add up those totals, you lose 0.3 of an acre. The first adds up to 11 as in terms of what it's from, and then it goes 10.7 to what you get. So somewhere 0.3 of an acre actually evaporate through the addition process, and I don't know how that happens. I've cited 9 different goals, objectives, and policies that I believe are completely, that this application is completely inconsistent with. I don't have time to go through each of those. I do want to mention a few things about the issue of compatibility. I made my first visit to this area last Thursday afternoon. I was utterly charmed. This is a gorgeous area. It's funky, it's eclectic, it's got a little bit of everything, but it works. They all go together in a meaningful fashion. You don't have the same uses, but you do have some commonality in scale. This thing, in terms of those very same factors, this would at once become the largest building in the entire area, the tallest building in the entire area, the one with the greatest bulk. Nowhere else do you find a site with 141 parking spaces. This is completely uncharacteristic and incompatible with the area. I think when you put something like this in, you create destabilizing factors that can do nothing but hurt you down the road. Do I have to stop here? Yes. I could go on for quite some time.
Sir, make sure your report gets to the clerk.
Yes, and I'll provide one to the commissioners as well.
We weren't provided that beforehand?
No, sir.
I didn't see it.
I will distribute it right now if that's allowed.
Probably be.
Submit it to the clerk.
If you want it to be part of the record, it has to get to the clerk.
Yes, I want it to be.
And you can distribute a copy to each of us right now while we're listening and talking. Ms. Estes, or you represent yourself or a club?
Citrus County Council, the Governance Committee. I realize that you do have copies of the before and after the 31 and the 110, because this is important regarding the canal for what I'm about to read you. This is directly from your comp plan. The first one I'm going to talk about is Chapter 2, page 24, the corridor. Did you know that Halls River Road is a scenic road? And there's guidelines as to what you can and cannot do on that road. So I'm not going to read this into the record because it's going to cut into my 5 minutes and I could be here for an hour. So I'm going to cram all this into 5 minutes. So just remember, Halls River Road is a scenic road. And the scenic roads may become attractions for tourists, enhancing the economic base, not the other way around. Next, let's go to, excuse me. Then we go to page 242, and it talks about scenic roads again, and it talks about how they're vital in order to preserve the aesthetic character of these areas. So again, you'll be going against your master plan if this is approved regarding the roads. Going to Chapter 3, we want to introduce the current trends and everything, and so we're going to go to the back here, and it talks about the importance of keeping things aesthetically and natural as possible in these areas. So on page 3.1 and 3.2, I want to just enter that into the record so that can be used later on in a court or law. Somebody can read it. We want to go to page 4.4, and it talks about springs and rivers. And again, and the reason I ask you about this is because of the runoff that this is going to occur on here. And you're not allowed, by your own comp plan, allowed to do that. Reason being is the 110, you're going to have 110 units, you're going to have your restaurant traffic back and forth, and you're going to have more than 15 employees back and forth, then you're going to have service trucks back and forth, and I'm not talking about concurrency. This is runoff and the effect it's going to have on the existing canals, which you're not allowed to do either, because this is not 1,000 feet away from the river. On page 4.7, it talks about preserves and special designations. Page 4.8, the St. Martin's Marsh. This is another one, why this canal, because that canal now, when it's paved over to increase the footprint for this application, is underneath the hotel now. It's gone. There's no more water. It's now underneath the hotel. And a page 4.9 for the record. Then again, on 4.10 of your code, it says the dominant land use within the coastal area is conservation, not hotels. Conservation brings tourists. So I'd like to enter that into the record. Future land use impacts. Impacts to natural areas and coastal areas and future population should be minimized, not increased. What this applicant is asking you to do, he already has property rights, so this is not a property rights issue. Property rights have already been extended to him, and most graciously by this commission. He can already go back and do the 31. What he's asking you to do is increase density by adding more population to this area. And that's what he's asking you to do by approving the PUD. He cannot do this without the PUD nor the restaurant. Let's talk about page 414. Let's talk about current conditions and excuse me, I can't say the word, point sources. Thirdly, this is number, oh crap, excuse me. Non-point sources, 415 in your code book. You're not allowed to do that. My main thing is, too, there's no report in here about police and fire response time. How are they going to get there? You know, no police, fire, or anything else here. This is not bound on 3 sides by like property. There's nothing in there that even remotely looks like this. I talked about roads and everything. And again, it's not a property rights issue. He can already do what he wants to do on this property while any other authorization for you. You are not legally bound to do this. So with that, I have more to go. I was going to go through staff's reports because they're using words such as, it appears to be compatible. It either is or isn't compatible. End of story. Please deny the application. Thank you so much.
Thank you. Would the next individual please come forward? Thank you, ma'am. Please turn your green card and speak into the microphone.
I'm Carol Pellegrini, and I represent the Riverhaven Village Garden Club, also myself. I have written to some of you, to all of you, but I have other issues that I wanted to talk about tonight. I live in Riverhaven Village, and I never understood how Riverhaven Village got built because of the wetlands. And I guess we were in a different generation, and things have changed, I hope, since then. I'm very concerned about the Halls River proposal. This land consists of 11 acres, and no matter what you call it, designate it, Disneyland, planned, whatever, it's 11 acres, but 4.82 of those acres are buildable. 6 plus are wetlands. You can't build on wetlands, whether they're pervious or impervious. That was something new to me tonight. But you can't build on them. It's not stable land. So we're talking about building on 4.82 acres. And what we're doing is we're putting 2.4 acres of paving impervious material on 4.82 acres. And then we're building a building of 4 stories height and of some area, a pool with a deck around it. And this is all coming up to 1.24 acres. So now we've got, out of 4.82 acres, over 3 acres of building and impervious material.
You got 57 seconds.
It was fast. That's 75% of the buildable land. 75%. That's almost all of it. And our regulations say 70%. I want you to imagine if you owned a piece of property that was 5 acres. Can you imagine a 4-story hotel, 2.5 acres of paving? You would have just the outer edges of the land, like you have up in that map right there, past the white of remaining land. Not too much flora or fauna there. Now, the applicant is saying that this is going to help tourism, but I ask you, is it really going to help tourism? Are we really going to get benefit from it? Because all of this runoff is going to have an effect on the rivers, and people have already said this. So I ask you, will we still have tourism and attractions in 100 years if we do this? Thank you very much.
Would the next individual please come forward? Please state your name for the record, ma'am, and who you state, whether it's an organization or personally.
Good evening, Chair. This is Teresa Waldron, and I'm representing the Citrus chapter of the Native Plant Society. And we have 64 members at the moment, and we had a unanimous vote for me to come and speak with you this evening. I'm not a numbers and a calculating and a document supplier. There's enough of that today. I'm talking about Old Florida. And Old Florida is what makes money, because the ants from the city come to the sweetness of nature. And once this is spoiled, you might as well call it Miami. So that's all we really want to save here, because that is why every person in this county is here. If you didn't like it, you'd move. And that is what runs our economy, and that is what is going to feed our children and our future generations. So, thank you.
Thank you. Hello, ma'am. If you would please turn your green card in and state your name for the record, and if you're representing yourself or organization.
My name
Speak
is
into the
Priscilla
microphone.
Watkins. I'm representing Save Our Springs Now. Save Our Springs Now is a consortium of 5 nonprofit organizations who are concerned with the outstanding Florida waters in this county. The group includes Chaswitzka River Restoration, Homosassa River Alliance, Rainbow River Conservation, Save the Manatees Club, and WAR. We also have about 80 affiliated, I think it's more now, but I don't have a latest count, of organizations throughout the state and a few regional ones that are working with us. And as a disclosure, SOS Now, because of recent interpretations of state law by SWIFMUD, we have been in litigation with the Department of Environmental Protection since March 2013 on an issue that impacts all of the outstanding Florida waters in the state, and we're currently waiting for another determination in the Florida First Court of Appeals. If you want the case number, I can give you that.
No, ma'am, you probably want to stick with the issue so we can.
It's part of the issue
Okay,
because
all right.
we are opposed to the application for Halls River development on the following 2 points. It's incompatible to the surrounding area and the high hazard to the wetlands where it would be situated. And number 2, the proposed commercial venture and its impermeable surfaces would cause increased contamination of rivers already challenged by severe human-created degradation. Our suit is in reaction to the minimum flows and levels application. And I will very quickly say that the count of housing units along the area in Halls River from Fishbowl on up was collected by myself. One of the utilities provided backup to my physical count. So if there's any misunderstanding about where that 587 residential and 8 commercial areas go, talk to me. The other point I want to just briefly respond to Mr. Stillwell saying Catherine's Bay is right around the corner, because he wants to say the project is compatible with its neighborhood. Well, if Catherine's Bay is right around the corner, where I live in Riverhaven is right around that same corner. That's all. Thank you.
Thank you, ma'am. If the next individual would please come forward, turn in your green card, ma'am, to the clerk. Please state your name for the record and whether you're speaking as an individual or representing a group.
My name is Marcia Wills, and I'm speaking for myself, nobody else. I moved here to Homosassa from California. I moved here for the nature, for the area, for the water. I've seen this river change in the last 7 years. I've seen the fish depleted. I've watched the manatees be depleted. This river gets a lot of use. We get a lot of people coming up from Tampa and all over for scallop season. It has become a nightmare getting down the river, but that's another story. I'm still a working person. I go to work, drive by there every day, twice a day. There's going to be delivery trucks there. There's going to be people coming in and out, and I'm against it. I just don't think it's right for this area. And that's really all I had to say today. Thank you very much.
Thank you, ma'am. If the next person, ma'am, if you'd please come forward, turn in your green card, state your name for the record, and whether you're speaking for yourself or a group.
I have copies for you of what I'm going to say. Can I just give it to her also?
You can hand them up here if you would like. Give her one and then give us one.
Good evening, Commissioners. I'm speaking for myself. My name is Iris Rose. For the past 12 years, I've lived off of Halls River Road in Homosassa. I'm also a member of the Homosassa River Alliance. Soon after living here, or moving here, we were required to hook up to the sewers. We were more than willing to pay the money to do this so that the river would receive less contamination from septic tanks. We believe that by doing this, we would be doing our part to help restore the quality of our spring system. I attended meetings where the BOCC, county staff, SwiftMud, and the DEP assured us that installing the sewers would not increase density or intensity of land use. If anything, the sewer system would serve to enhance existing development. In relation to this, I would like to read from the Comp Plan, Chapter 10, Future Land Use Element. This section is titled Coastal, Lakes, and Rivers Region. Quote, the environmental suitability analysis has documented the environmental sensitivity of the lands in the coastal lakes and river region. The county is continuing in its efforts to provide central, regional sewer and water service to its residents. However, just because regional sewer and water service becomes available in portions of the coastal lakes and rivers region, this does not necessarily mean that the area is now suitable for increased density and intensity of development. On the contrary, with increasing development, activity, and growth in the coming years, existing restrictions on the density and intensity of land use should be maintained and enhanced to provide additional protection to this sensitive region. Expansion of regional utilities in this region is designed to serve existing vested development and to eliminate the adverse impacts of numerous septic tanks and package treatment plants. Consistent with the plan's basic strategy for protection of this region, the following guidelines shall apply. This is in the comp plan. No increase in residential density should be approved except for the planned development standards already contained in this plan. No additional high-intensity non-residential land uses shall be approved for this region. So, tonight, I am respectfully asking you to consider what we were told, consider what I have just read to you when making your decision regarding the Halls River development. If anything, greater restrictions should be added to protect this highly sensitive area. You know, the people that live in Homosassa don't have a mayor. We don't have a city government. We only have you. You need to protect us. Please keep that in mind when you make this decision.
Thank you. Leave. Doug. Hey, Doug, would you go over and that mic come loose right there? If you put the little clip up there. The little mic came loose off there, Doug. Please, sir.
The Army taught me to shout. They did.
All right, no war stories. Okay. All right.
My name's Al Grubman. I live right around the corner, and speaking for myself. Some of us were born here. Some of you left here and came back. My wife and I traveled Florida for many years. Then we fell in love with the nature coast of Citrus County. This summer will be 14 years and we still love the county. Most of us love the environment. The environment is the best part. The worst part is the attacks on the environment. A few years ago, the few acres on the little road entitled to one residential unit and no commercial units was the way things were. We have been attacked several times for the bigger allowance. Even losing court cases have not stopped the attacks. Now our Board of County Commissioners has been asked to approve a 4-story, 110-room motel, which I hear would be built on top of a 9 or 10-foot berm. Somebody said the biggest thing in the county. Please, commissioners, for all the reasons you know from the past, attempts, dangers, staff concerns, laws, hurts to our environment, and more that you will hear yet tonight, please say no to this assault on our friends and neighbors. Thank you.
Thank you. Would that next individual please come forward, and Ms. Grubman? Mr. Grubman just left. If you'd please state your name for the record.
Hello, I am Jan Grubman, and I too live just around the corner. Usually, I am the flowery speaking person, but I came across, instead of my husband, but I came across some things that I thought were really interesting, and I hope you'll find them interesting too. There's a bit of history, but something at the end that I really want people to hear. This property has been before the County Commission twice before, each time resulting in litigation challenging the BOCC decision. Most recently, while the litigation was ongoing, the county adopted a new land development code. Among the changes was that in the recreation designated areas, a recreational resort went from being a conditional use to being a permitted use. The primary difference is that as a conditional use, the application required BOCC approval, whereas a permitted use could be approved administratively. With the new LDC, the applicant submitted a new request for a site development plan, which was then approved by staff. This new plan was submitted to the court as being a properly approved plan and therefore not subject to the issues in litigation. The court so ruled. However, it's stipulated. This site development plan approval order is a separate independent site plan and development approval order issued per terms, conditions, and authority of Citrus County Ordinance Number 2012-6. Excuse me. In the event of a conflict between this order and the PDO approval in Ordinance Number 2011-A-16, the PDO shall apply unless more restrictive terms and conditions are within this approval order, in which case it shall apply. Among the differences is that the new approval order allows for the so-called canal to be filled or altered. The more restrictive approval order ordinance does not so provide, the applicant's assertions notwithstanding. The following statement by staff contained in the third paragraph of Exhibit G is as follows. Note, the narrow man-made on-site canal area will be filled. It is not part of the Homosassa River, nor part of the OFW designation of the river. The bottom as such is not sovereign lands. Functionally, it serves little purpose given location, size, depth, and width. unquote. Please deliberate, keeping the following in mind. Local people familiar with this canal or water feature remember that in 1992, dock masters installed seawalls on both sides when they built the dock on the property. Commissioners, contained in the package before you, this water feature is shown on BOCC GIS maps as an integral portion of the Halls River, which is identified as an outstanding Florida water. This depiction is consistent with the maps found in the property appraiser's GIS and the 1-foot contour lines found on the maps placed online by SwiftMud. The bottoms, therefore, are sovereign lands and are subject to pertinent laws and regulations.
Thank you, Ms. Grudman.
Thank you.
Sir, if you would please turn your green card in, state your name for the record, whether you're representing yourself or a group.
My name is Stephen Mengai. I'm representing myself. I live here in Homosassa. I'm going to do a little different take on this, but it was addressed, I believe, by the judge back in 2002. A little background. I am a retired professional firefighter with 31 years of experience. I worked with Orange County Fire Rescue. Many of those years I spent assigned to International Drive, which is the tourist area, all the high-rise hotels. I was both a firefighter and a command officer, so I have experience when it comes to high-rise and hotel fires. I think we could all agree that public safety is a basic core responsibility of government. If as a county we are going to prevent the construction and subsequent housing of families on vacation, then we have a responsibility to protect them. According to any recent studies and data available, and any of them, the Citrus County Fire Department is currently understaffed and under-equipped to handle a fire and a rescue in a 4-story hotel. Is Citrus County willing, is it able, to make the changes necessary to adequately respond to such an emergency when you have potentially hundreds of lives at risk, including those of our firefighters? As a taxpayer, I would have to ask you how we would pay for such an expense. As it stands right now, our fire department would respond with a fire engine staffed with 2 firefighters. The closest ladder truck, which is I give you, is a very nice ladder truck, would respond from halfway across the county. And again, it would only have 2 firefighters, and that's what would be used to reach any trapped victims on the upper floors. Also, would it be unrealistic to assume that the owners of this newly constructed hotel, if it was done, who as it stands now wouldn't even pay any impact fees, might come to the county later and insist that proper fire equipment and personnel be put into place to protect their investment? Why, as taxpayers, wouldn't they? I've watched the same thing happen in Orange County, so why not here? This is not my opinion. There's not just some firefighter talking. These are all facts and statistics from the National Institute of Standards and Technology, the federal folks who do all the studies on what it really takes to successfully fight fires and save lives when a building such as this has a fire emergency. And when you really look at what it takes in personnel and equipment to supply water, climb multiple flights of stairs, fight fire, and rescue trapped, scared, and potentially injured people from the upper floors of their hotel rooms before it's too late to help them, you will see that Citrus County FD cannot accomplish this at this time. This is absolutely no disrespect meant towards the Citrus County firefighters or their department. I am sure they would do their absolute best and whatever they could, even at the risk of their own lives. But they just do not have the resources to make it a fair fight in a building of this type. All this can be addressed, of course, but it takes money. Or we just pretend that we have a proper fire and life safety services in place and then live with those consequences if it all goes bad.
My name is Ed Lutkus. I'm a resident of Homosassa, and I'd just like to make my comments very brief. When I graduated from medical school, I took an oath that said, "First, do no harm." I think everybody here would agree that's a pretty good adage to live by. this project does harm to our neighborhoods and to our communities and to the environment. Secondly, we were also taught in medical school that just because you could do something doesn't mean you should do it. I don't think we should do this project. Thank you.
Ma'am, if you'd please come up and turn in your green card and state your name for the record in the mic.
Hi, I'm Mary Lott. Makes me a four-letter word, huh? I do not live in Homosassa. I live in Inverness. I'm here because my husband decided when he left Guam to check his father's estate that he would come to Florida, visit friends, and I got a call that said, "Guess what? I bought us a house!" Now, you know why I don't have firearms in my home. And I thought, why in the world would you leave a beautiful Pacific island and come to Florida? Are you nuts? And then we came here, and it was wonderful. As far as the natural world, the things that are going on, and I've looked around and thought, yeah, we can do this. One small story, I had the privilege when I was a 17-year-old college freshman to meet Dr. Albert Schweitzer and to spend some time with him. If any of you remember who he is. His philosophy was reverence for life. The wetlands are a nursery, a sustainer, the umbilical cord from which so much of nature comes from to enhance us. It isn't reverence for life just for us and what we can do and what we can have. Reverence for life is so needed. Where are we going? And what are we going to do when we finally render the last corner of Earth uninhabitable? We're doing a small section of that now. I know the Supreme Court says money, 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 they win. Please, please, please don't do this. Please show them that we have some reverence for life as well. Thank you for your time.
Thank you, ma'am. Ma'am, if you'd please state your name for the record and speak into the mic.
Yes, I live in River Haven currently. I taught art for 32 years in Fort Myers before coming here, and the reason I came is much the same as other people have mentioned, to really enjoy nature and the Nature Coast. But, you know, when it came to getting in line...
What is your name again, ma'am? Sorry about
Elizabeth Frank. When it came to getting in line, when you first called the lines to form, I just wasn't sure which line to get into. I thought, gee, I'm an art person, and I've studied monuments all over the world. There's Paris and the Eiffel Tower, and there's the Taj Mahal in India, and gosh, what about St. Louis and its great arch? But as beautiful and wonderful as Homosassa is, there was no monument in Homosassa. Well, there were the eagles and the osprey and the swallowtail kites and all the fish in the rivers and all the fishermen fishing for those fish, but no monument. And I thought maybe an obelisk with all the pelican on top or something would be appropriate, somewhere to be seen by everyone along the Homosassa and Halls River. And then the hotel plan you see in front of you pops up 50 feet or more high. I thought, there's the answer. There it is. There's the monument. that we needed in reverence of the nature of this part of this parcel of Nature Coast. How wonderful. We don't have to pay a dime. It will be built for us, all 50 feet of it, and all big enough to be seen, surely, from Blue Springs to McRae's, all up and down the Halls River, across the river, by all the people in the river, going along the river or in boats along the river. It will be wonderful. And I thought maybe to really honor the BOCC, that the names of our commissioners who approved this hotel should be inscribed on a plaque by the hotel's front door. I think it would be kind of like the wonder of seeing an Eiffel Tower on the rim of the Grand Canyon. Really appropriate.
You got well, it looks we're down to Mr. Schultz and Mr. Bartell. They've been here before.
Mr. Chairman, members of the commission, staff, citizens, I started to say good afternoon, but good evening. For the record, my name is Ron Schultz. I reside at 4215 South Purslane Drive, Homosassa, Florida. I am speaking for the board of the Old Homosassa Historical Preservation Society. Professionally, I served as a county property appraiser in Florida for some 24 years, and I hold the professional designation of State Certified General Appraiser. In my opinion, neighborhood is a primary determinant of a particular property's utility and value. This is a reciprocal relationship. The neighborhood determines the perception of the individual property, but the property adds or subtracts from the nature of the neighborhood. In reviewing this application, I first sought to quantify the neighborhood. In this case, the neighborhood is almost self-evident. It consists of all the parcels that can be accessed by a vehicle from the Halls River Road, beginning at the intersection with Fishbowl and ending at the emergence of River Haven Drive. This area is effectively contained by the Halls and Homosassa Rivers and the St. Martin's Marsh. I contacted the property appraiser's office and ordered a map of this area with some parcel identification information, as well as machine-readable data sets. I've delivered these and a copy of my comments for the record. This research showed that the entire neighborhood, as described, consists of some 294 parcels, with 266 being single-family residences, 175 site-built homes, 60 fixed mobile homes, and 31 condominiums. In addition to the residences, there is a marina, a clubhouse, 2 RV and camp facilities, a restaurant, and since the wildlife park backs up to the Halls River Road, several structures related to the park. My primary intent was to identify existing transient housing facilities so that I could find a number of units and I could compare them with this proposal. My search of the property appraiser's records revealed some 58 such individual units with a combined enclosed 31,000 square foot of rentable space. This proposal would add 110 individual units and some 48,000 square foot, thereby having a change of 253% and 289% respectively, thereby fundamentally altering the nature of the neighborhood, a 300%, almost 300% increase. In the comprehensive plan at policy 17.15.9, we have, the county shall establish standards to address compatibility between adjacent land uses and within neighborhoods and larger areas. Skipping a little bit, to ensure that the new development and redevelopment is consistent with the character of its environs. This fundamentally changes are the nature of that. By the way, this project has been identified as a water-related PUD. Every year, Citrus County receives a massive in-migration, known locally as scallop season. Most of these hundreds of people arrive with their boats in tow. Many stay for a weekend or a week. Please imagine 100 or so customers coming to this facility with their boats, only to find that there is no provision for parking their trailers or their boats. They will have to leave them on the shoulders of Halls River Road. This will become more than a neighborhood nuisance. They will become a danger to anybody driving that road. Please, for both aesthetics and safety, do not approve this application. As an aside, living on the Homosassa River, I've always considered that seawalled area as part of the Halls River and have been up there. Thank you, Annie, for the evening. Appreciate it.
Thank you, Mr. Schultz. Mr. Bartell, if you'd please state your name for the record and if you're representing yourself or a group.
Mr. Chairman,
Mr.
members
Bartell.
of the Board of County Commissioners and county staff, I've heard here tonight since the start of this ordeal, if you will, a lot of technical information, both from this gentleman, both from the applicant and also from you all listening to the information. I'm going to take it from a little different viewpoint. I'm going to put common sense and ask you all to use common sense when you address this issue. This application has been in front of the Board of County Commissioners even when I was there. And I tell you, it's a no-no situation. I don't care how much money the applicant makes over it. I care about once it's done, what's it going to do to our community. My children and I and my wife, we live on the Halls River. We see what happens when it gets during scallop season and overcrowded. And I'm going to stop here and I'm just going to ask you all to stop and think whether or not you would like to live in that type situation. The applicant bought the property. He knew what he was buying. He paid the price for it when at the time, and now he's trying to make money off of it. I'm sorry. I don't buy that. I just don't buy that. Please turn this application down and let the Halls River live in the way that it lives today. Thank you.
Thank you. Sir, if you'd please state your name for the record, and are you representing yourself or a organization?
I'm representing myself. My name is Brent Strange. I live on West River Cove Place in Homosassa. And if you drew a circle around the hotel, my house would probably be within the circle. But if you draw that other diagram, screwy picture that they had, I'm not in that area, but I am a neighbor of that. So if, with the applicant's permission, could we go to slide 1 of this presentation?
No.
Do we have the capability to do that?
No, sir.
Okay.
We better.
I'd just like to refresh everyone's memory to the very first slide that we saw there. And what were those pictures? Those were pictures of bucolic experience of coming to Homosassa, Citrus County. We have kayaking, we have the nature, we have the water. Did we see a picture of a 4-story hotel in the background of any of those pictures? Did anyone see that? If I'm driving down 75, I expect to see a 4-story hotel on the corner. But if I'm kayaking down the Halls River Road, I don't expect to see a picture of the hotel. So where are we going to take that picture from now on after that hotel is built? Where do we have to go to take that picture? That's what I would like to know. A couple of points that the attorney brought up. Okay, we have 31 cabins with 2 bedrooms each. Okay, he's trying to equate that to not much of a leap to 100 units. Okay, I don't know what the square footage is of the cabins, but I think that's a pretty large leap. If we take 2 bedrooms times 32 cabins, that's 62 units. That's a 40% increase to a 100-unit hotel. So that's a pretty large increase to me. And he talks about the neighboring property of being an RV. Well, I haven't seen any 4-story RVs looming over the treetops. So when I kayak down the river, I really don't want to see a 4-story hotel. And I don't think anyone in this room wants to see that either. I think we're all here to support nature in the Nature Coast. We market this area as nature. So how does a 4-story hotel on the edge of the water compute to marketing nature to the people that we want to bring to the area? So please support the community. Thank you.
If the next individual would please come up, sir, please state your name for the record, and if you're representing yourself for...
My name is David Huey, and I represent myself. I've lived in River Haven for 13 years. There's over 500 homes in our connected communities with Gasparilla and Shadow Woods. We have about 1,000 residents at the end of this road. I would like to speak on public safety, and I commend my brother, firefighter from Orange County, wherever you are, that he did a good job in his presentation, and he's going to cover a few things that I've already covered. My qualifications to speak on public safety is I'm a retired professional firefighter, EMT, for 22 years with the City of Orlando Fire Department. I served as a fire officer. I've served in the high-rise districts of downtown Orlando. And as a fire officer, my responsibility included company safety inspections of commercial buildings. It also included pre-fire plans that we had to make, that I personally have made on commercial buildings. So I'm familiar with a lot of the infrastructure. As a resident and concerned citizen, I ask the Commission to consider carefully the definition of a high-rise structure, which is any structure above 3 stories. The structure is a high-rise building, the structure we're talking about. And it requires specialized firefighting equipment not in place at this time. I clocked the distance from McKenzie Firehouse to the Halls River Road project. It's 14.7 miles. That would probably give a response time of about 18 minutes for a heavy ladder truck, which we'll call an aerial truck. And that's critical time to rescue people. If your regular fire engine shows up, you have a 24-foot ladder. It'll only reach the 2nd floor. It doesn't make common sense to not build tall buildings unless you put them in an area where a ladder truck can service them. Most cities consolidate their high-rise buildings in one area so that they can have a ladder truck service it. The response time is critical. There's limited sight on the road. It's going to be a dangerous spot. We live on an island. There's one way in, there's one way out. I'd like to speak about the NSPU tax at 5 cents per square foot. I did the math. It's about $2,600 annually, which is barely the cost of fuel for one fire engine. It's not going to pay for itself. A new ladder truck can cost up to $500,000. If the water supply is not adequate for this building, we can spend millions of tax dollars trying to take care of this building. So in closing, I say that I moved here because it's a preserved natural beauty area, and this project is the beginning of the end of our pristine river and our way of life. 3 recommendations: only build high-rise structures in consolidated areas, only build 2-story structures so a standard fire engine can service it and rescue people, and do a flow test on your hydrants to see if you have enough water flow. Thank you.
Hello, ma'am. If you'd please state your name for the record. And
hi, my name is Sandy Meyer, and I live in River Haven. I've lived there for 12 years now. I guess my first question would be, how would this structure, this project, benefit Citrus County? There will be no impact fees as of now. Maybe that will change in the future, but as of now, there aren't any, right? I'm correct?
Correct.
It will not give a lot of jobs, and I think it will hurt tourism because of what everybody else has said. People come here to boat, to fish, to enjoy nature, to enjoy our wildlife. We don't even know what the impact on our wildlife will be yet, but I'm sure it will be substantial. just from lights and of course, all the impervious ground. The road itself, I think I'm correct in saying 4 people have been killed on that road since I've lived here in 12 years. It's very narrow. It's curvy. We do not have any side area for walking or biking. That is one of the most dangerous curves right there. I have seen accidents many times, or near accidents, just from people coming out of Margarita Grill. And all that is a restaurant. I don't know what its capacity is, but certainly not a potential of 440 people in that hotel, because the rooms probably will sleep 4 people. Where are these people going to go if we do have a big storm or hurricane, where they will have to be maybe put in shelters? We don't have the room or the facilities for those people to be. Not to mention, we aren't counting all the people that are in Nature's camping or in some of the other little cabins camping. We've got our 587 houses we have to try to think about saving our lives, but then you've got all these other people. It's, like I said, the road is dangerous. The danger during a storm, the danger during fire. If all our trucks are going to be there fighting the fire, what happens if one of our houses catch on fire? The road will be blocked, number one. Not to mention all the purveyors that are going to be coming in and out, the garbage trucks and the food supply and the linens and whatever else comes in and out. It's all too much for this small little area.
Thank you, ma'am. The next person, if they'd please come forward. Yeah, state your name for the record there.
Don't be too quick.
I'm not.
Who gets this?
I know you're speaking for a
Can I speak
organization.
Good evening. My name is Joanne Bartell. I live on the Halls River on West White Dogwood Drive. Very quickly, before I get into what I was going to talk about, the woman that was just here and another one earlier both spoke about evacuation. The county policy says that the evacuation time to the shelter must be 12 hours or less. Right now, according to the most recent county study, it's 12.5 hours to the nearest shelter.
Hours or miles?
12.5 hours is and that's evacuation if only a small area, the coastal area, is evacuated. The larger the evacuation area, the longer it's going to take people to get there. There is also a serious shortage of shelter space. I don't know if you were aware of that, but there is already not enough beds for people. All right, Halls River. The predominant use on the Halls River is conservation and residential, other than the Nature's Campground and the current site plan for this proposed project, which is a recreational campground use. Trying to compare that to this site plan here, I'm at a loss, but if you all will take a look at this, you have your 3 areas, and this is the applicant's site plan. You have this area here marked as a wetland, this one down here, and this area here, and if you add these 3 numbers up, you come up with 4.87 acres of wetland. Now, county staff report and the applicant's materials say that there is currently 6.74 acres of wetlands. Where did they go? That's 1.81 acres of wetlands that's missing from that site plan. County code says that if you're going to come here and ask for a land use change, you must have a jurisdictional wetland map that shows where all those wetlands are. If they're there, I hope the applicant's going to come up here and show us, because there's some serious problem with the numbers here. Also, if you look at these numbers that they placed over here, they say that the wetland area is 6.18 acres. Again, if you add up their numbers, and this is the applicant's site plan, it's 4.87. Somebody needs to ask that question, what's the disparity in the numbers there? There are many discrepancies. Unfortunately, I only have 3 minutes, so I can't go through them, but this plan here says that they need 1 parking space for each room. County staff report says they need 1.1. There are just so many different mistakes in there. This site plan says that it should be reviewed under the small project code. County staff says the large project code. If you all approve this tonight, if you look at your list that it says of here's what you're approving, you are approving everything that the applicant submitted. So you would be approving these numbers that are internally inconsistent. I hope that you'll give me the extra time just to say that, as a person who lives on the Halls River, I use that river every day. I am out there. I'm a kayaker. I have been boating on that river for probably 30 years now. I'm going to enter into the record these 3 pictures, which I've entered into the record previously. These were actually taken along this site in the canal back a number of years ago. It's a picture of black spotted bass minnows. The bottom there used to be very sandy. Now I know that today that there's a lot of leaves and silt that have settled to the bottom, but there used to be little spring boils right up there, right up in the head of this canal that's here. My knowledge of that canal is that at one time it was wetlands, and the owner of the property dredged it to get a bigger boat up in it. It was not uplands that was cut into a canal. It was already, running water there. He just made it a little bit deeper.
Thank you.
So, and I thank you very much. I'm going to turn in these policies that I believe are inconsistent with the application, and I hope that you all, in your infinite wisdom, decide not to approve this project.
Do you want to?
I just have 1 copy here. You're all free to look at it as long as you pass it back to the clerk.
All right. Thank you. You want to grab your map too, Ms. Bartell, please?
I believe the attorney
Oh, you got it. Sir, if you please state your name for the record and who you represent, and speak into the mic.
Good evening. My name is Ralph Brooks. I'm an attorney, and I'm certified in city, county, and local government law. And I represent the Homosassa River Alliance, Inc., and many of the individual members that have come before you today, as well as concerned citizens that live on Halls River and that live in River Haven also. I've been county attorney, assistant county attorney for Sarasota County, and I was land use litigation attorney for Monroe County, which is the Florida Keys. I'm a city attorney as well. I've been city attorney for the city of St. Pete Beach, which is in Pinellas, Bradenton Beach, and Manatee County. And I'm currently the town attorney of the town of Yankeetown, which is nearby in Levy County, where we faced a similar 100-room hotel on the banks of the Withlacoochee River that the town of Yankeetown Council turned down. First of all, I'd like to tell you that this particular site plan violates the impervious service ratio. The maximum lot coverage on CLC is 35%. If you look at these numbers that are here, there's a number there of buildings, square footage, just buildings. That's 51,623. That's 1.18 acres. There's 43,560 square feet in an acre. If you take those numbers, that building, and you building area, and you add in the wetlands that are on the site, the 6.18 acres of wetlands, and you divide that number, which is 7.35, by the total gross site area, which is 11, you have 66.9%. Why am I doing the gross site area? Because that's what your section 1500 on page 1-27 of the Land Development Code has for your calculation. Total impervious surface over gross site area. Why am I including the wetlands? Because in the section 1500 definition of wetlands, it says, for the purposes of development review under the LDC, wetlands are presumed to be impervious. So you've exceeded it if you follow these definitions. Even if you don't follow the wetlands definition, and you simply take the number 2.4 acres which is what they calculate their impervious surface acreage to be, and put it on that map, and over 4.82 acres, which is what they list, their upland acreage, that comes to 0.498. That's 50%. So that, again, exceeds 35%. So they violated that provision of the code, the Land Development Code. The Land Development Code also doesn't actually allow planned developments in CLC. I know you approved one before. I wasn't challenged on that basis, but if you look at page 2-21 of the Land Development Code, there's a table as permitted uses and conditional uses. Conspicuously absent, which is present in other categories, is the planned unit development. Planned unit development is allowed in the CL, which is the wetland area, but you have to have at least 160 acres minimum, and that's under 24.01B1. And that's in the comp plan, or excuse me, Land Development Code. The CLC is found at 2410, section 2410, and what's allowed there. Now, there is something called a waiver or a variance, where you can get a variance or a waiver from the impervious surface ratio or maximum lot coverage, but they never applied for one. Here's the form that you would use to apply for one. I'll turn that in.
And who does that form go through, sir?
It goes to the planning and land development, and you can ask your staff about who handles that. I'm not sure. I'm also here to tell you about the big picture. Snyder versus Brevard is the Florida Supreme Court case that talks about rezonings and what your standard is. First of all, they have to prove that they're consistent with the comp plan. Even if they are consistent with the comp plan, you can still deny a rezoning if there's a legitimate public purpose for denial. The comp plan amendment that's before you has another standard. That's legislative. You will not be forced to approve a comp plan amendment, and no court will overturn a denial of a comp plan amendment if there's any rational basis, if there's any reasonable economic use of the property, and if you'll remember, they already have a campground here with a number of RV sites. The plan amendment shouldn't be approved, and if you shouldn't approve a plan amendment because it has internal inconsistencies in it, as were pointed out to you, the numbers don't match. There's inadequate and inaccurate data and analysis about the wetlands that are on the site. And I'm not sure how many acres total of small-scale plan amendments you've already approved this year, but you're only allowed to approve 120 per year of 10 acres or smaller. This is 11 acres. I'm not sure how they're getting a small-scale plan amendment either. Just one more minute. Thank you. This is not only next to and on the outstanding Florida water body of Halls River, but across the river, only a few hundred feet away, is the St. Martin's Marsh Aquatic Preserve. And your comp plan says that you shall designate low-density land uses adjacent to natural land reservations and resource-based parks where adjacent lands are undeveloped, and that the county should direct land uses which are incompatible with the protection and conservation of wetlands away from these wetlands connected to outstanding Florida water bodies, and that parcels that include or are adjacent to conservation areas like the St. Martin's Marsh Aquatic Preserve shall not receive future land use designations that are higher in intensity than the currently adopted designations. And that's policy 3.16.12. And Ms. Bartel turned those in. I have an extra set of these I can pass down, and as well as the definitions. I do want to just tell you to wrap up that the Belleville Hampton Inn, you've all seen it. It's on I-75 in the corner of 484. It's 4 stories without parking underneath, which is shorter than this one. We don't want that right on the Halls River, no more than Yankeetown wanted that on the Withlacoochee. Yankeetown didn't have fire trucks that could reach the top of 4 stories even without the parking. We were taken to court by the developer, and we upheld that denial. So I'm very confident that you can uphold the denial of the plan amendment and the denial of the planned unit development that's been applied for here. Thank you very much.
Ms. Wade, if you'd please state your name for the record.
Ms. Wade, Ms. Janarone.
Janarone, I'm sorry. Ms. Janarone.
Gail Janarone, Crystal River. I couldn't compete with all these intelligent people here. They all had so much to say, and I agree with them 100%. Sorry, I'm losing my voice. The one word I didn't hear tonight, though, was precedent. This would be setting a precedent. All of a sudden, there's an RV park with a big parcel of land there. What's to stop them from wanting a four-story motel, hotel, whatever it is? It will be setting a precedent. But I think I found the best solution. I read in the paper this morning that Inverness thinks they need more tourists and more hotels. They got it.
All right. Ladies and gentlemen, if there's anyone else that'd like to speak, I think will Mr. Generon? Okay. And just so you know, this will go back to the applicant. Since we've had opponents talk, the applicant will have his rebuttal. So,
Phil Janner on Crystal River. If you can't make it fit, you must make it quit.
I think I know where Mr. Generon got that at. Okay. We will now bring back the applicant to, oh, sorry, we need to close the public portion. If there's no further public input, and anyone's welcome if they want to.
Mr. Roberts, would you allow me to just say?
No, ma'am. No. Because we've got to be fair to both sides here, and we've been back and forth, but we understood what you said, Ms. Bartell. So, if I'm going to call once for any more public comment, once, twice, 3 times. We will now close this portion to public comment, and if the applicant wants to get up for rebuttal, they can now come forward.
Did you want to look at your
What, did I miss something? Hang on.
reminder to the applicant?
Hang on, what?
Your reminder to the applicant?
Hang on, applicant. As a reminder to the applicant, your rebuttal is not a rehashing of the entire case that you presented us, Mr. Stillwell.
Oh, damn.
You are limited to address and rebuke that which has been testified to before the board during the open to the public.
Thank you very much, Mr. Chairman, and I am going to be brief, okay? First, I want to go to the ISR issue, okay? The definition in Section 1500, it says exactly what the planner and council said, but you go further into the code and there's a presumption. What Mr. Allison doesn't know and what council doesn't know is in the prior application, and Ms. Coutu knows this, is we demonstrated in the prior application that the wetlands were pervious. And because we demonstrated that the wetlands were pervious, that is, they drained, okay, the presumption was gone, and we're allowed to bring them back into the equation as far as floor area ratio and as far as ISR. So that's why the staff report says, you know, we meet at ISR, because, and I should have probably brought it up in the presentation, but that is in fact the case, and we've done that in other areas of the county, because if the wetland doesn't have freestanding water and it perks, it's no different than an upland area. So in this particular case, there is a prior administrative interpretation that those wetlands perk, therefore the presumption that's in the code is overcome, and we can use them in the calculation of ISR. Basic fact on wetlands is this: the yellow areas stay, the upland areas get developed, and the issues of the canal and what, if any, impacts there are to the wetlands on site has previously been determined and found valid. And we're not changing that. So this doesn't open the box. This doesn't reopen this part of it. That is what we call administrative res judicata. It's binding. So please keep that in mind. And I want to just talk about the issue of compatibility in the evidence presented. Classic public hearing. Person after person after person. What if? What if? What if this occurs? What if that occurs? Point source distributions. What about it? Are there any? No. Non-point source distribution. Are there any? What if there are? That was the testimony. That's not competent evidence. What if is not the test. The test is plan consistency and LDC compliance. Now, if you don't want 50-foot buildings in the coastal high hazard area, amend your code. But as long as it's there and we meet that, then we've met the code. And that's the test. Have you met the code? Now,
Mr. Stillwell, can I ask something? And
Sure.
when was that code amended to the 50-foot?
2010?
Or 2011? Or 2010?
Yeah, 2011. The standards in the 2012 code were readopted. So it's pre-2012 for sure. All right. Where's my PowerPoint lady?
PowerPoint lady.
I need the notice area one, not that one. It's got the line around it. Close. Nope. Come on. There. That's all. You see the dotted line? That's everybody that got notice within 500 feet. They got a notice at the PDC, and they got a notice here tonight. There are a total of 54 parcels in that area. Those are the people that per se have standing if they want to go to court. The court is going to say, if you're in that notice area, you got standing. You know how many people from that area testified at the PDC against this project? None. Do you know how many people from that area testified against this project tonight? None. The most directed people by this project in the four-story building, the people that are going to see it, as they say, every day off the road, and we've showed you the site plan that says that's probably not accurate. None of those people have chosen to oppose this project. That speaks miles to me, commissioners. They're the most directly impacted. It's their property values. They've got it on the line, and they didn't say anything. Now, to talk about compatibility.
All right, everyone.
There are 45 residential parcels in that area. Total of 21 acres, represents 14% of that area. There are 2 state parcels, total of 19 acres, representing 13% of the gross acreage. There are 7 commercial parcels in this area, represents 104 acres, representing 72.2% of the abutting landowners is commercial in nature, and I harken back to Ms. Katu's testimony that the RV is a commercial use. So 72% of the surrounding property area, 500 RV units, is what abuts this property. It's a commercial area, and we're putting a commercial use there. And those are the people that count, commissioners. So what I would say to you...
All right. Okay, everyone.
And that really leads me to something I forgot. This is not a popularity contest. Okay? It's not a question of it's not a question of how many people are in favor of it or how many people are against it. The case law is replete that when you say, everyone show me your hands if you're opposed to this, per se, not what you're supposed to do. It's not a question of how many people oppose it or want it. It's a question of consistency with the plan, the LDC, and protection per the master site plan. And what I would say to you is this site plan meets your LDC and it meets your plan. The policies that were read to you tonight by people that came up were the same policies that we were testified to in Catherine's Bay. And the same arguments were made in Catherine's Bay. And when we got to the first DCA, the three judges sat there and looked and said, you're engaged in speculation, you don't have competent substantial evidence, these what-if pie-in-the-sky policies, St. Martin's Preserve, discussion about that came up at the Planning Commission, and it was rebutted by your own planning staff. It says doesn't apply. And that's entitled to great weight. So we worked hard with your staff to try to get this to work. The compatibility test is that neighborhood, not anywhere else, and commercial to commercial is compatible. We meet the code. If you don't want 50-foot buildings, change the code. But don't set a standard out there and say, meet that standard, and then pull it out from under someone when they meet the standard. That's the rule of law. Thank you for your patience. We appreciate it.
Thank you, Mr. Stillwell. All right, folks. I'm going to close all further testimony and evidence. The board and the board alone may discuss amongst ourselves the issue and take action. It's open to the board for discussion and action. Board?
Well, Chairman, since there's somebody who's got to go first, I'm the newbie on the block, and here I am.
Yeah, hang on. Okay.
A lot of great points brought up tonight. One, I want to thank you for coming and showing your support, whether it's for or against, showing your patience and showing your professionalism. Why here? Why being in the meeting? My stance is this. Public safety that was brought up is a major concern, and it's something that we can't handle. There's no ifs, ands, or buts about it. Our number one goal sitting up here as commissioners is public safety. Number two, outstanding waterways. We've been working long and hard to change our habits to sustain what we have here in our waterways. Number three, it doesn't fit in. Would I like to see this at in a different place in our county that it does fit in? You bet I would. But unfortunately, this is not the place. This is not the time for this project. Let's make no mistake about it. The previous board approved this, not the current board.
Yeah.
So I could probably sit here and go on for a long time, but I think everybody knows where I stand. I'm not in agreement with this. I will not vote for this, and I'm going to turn it back over to our chairman.
Thank you, Mr. Carnahan. Here's where we're at. In 2011, sometime in that time frame, there was some adjustments in the code to allow for things to possibly happen like this. It does come down to law and the issues, and I do not support this because there's numerous conflicting information, but it's called quality of life and compatibility. I don't think it meets the criteria of compatibility and quality of life. We have our safety issues, and there's some mixed information on the impervious surface and a number of other things on parking that I think there's enough besides the quality of life, compatibility, safety issues with other issues that was brought up. I can't support this. And, you know, I think everybody lives here for the same reason. Commissioner Kitchen?
Want me to go?
Go ahead.
Thank you, Mr. Chairman. When it comes to these kind of issues, I do give them great weight because we're dealing, first of all, with people that want to come and invest in our community and spend lots and lots of money. And, year after year after year, we keep hearing attract business, attract business, attract business. So, first of all, you appreciate that when people do that, and I do give that great weight. And also, we're told it's not about emotion, it's not about what we think, it's about findings of fact. It's about what we perceive. The way this really is, folks, I think you see this, is we kind of set in a way a place of a judge. We listen to what we think is the evidence. We're only supposed to listen to competent evidence, okay? You hear that a lot. So I have to be careful. I've written down a lot of what both sides have said. It's interesting how it jumps around. I have nothing but the greatest respect for Mr. Stillwell, all the folks that were here tonight. I thought Mr. McCrae really kind of summed it up with, we're dealing with the best of the best at what everybody does here. But it was pretty interesting because I think Mr. Stillwell said, well, you can't deal with a what if. And then right after that, he said, the view probably won't be like that. So I have to say, that's not black or white. There's always going to be probablys and maybe. So what I'm going to say is my findings of fact were this, is that even when I look at the staff report, and I must say I have nothing but the greatest respect for our staff, but in reading this, I really think this was a stretch. This is my mind, is I really think that our staff really tried hard to work with the developer. But I'm going to come back to what I find on what's been given to me in the backup, and for reference, it was the board hearing April 14th, 2015, and it says the applicant, this is from, again, compatibility with adjacent land uses. It says in part, the application appears, once again, appears, not is, appears to be compatible with the surrounding area, although there are some concerns regarding the intensity of the project as compared to the previous approvals for the 31 cabins. And that's really what I'm coming back to, and that is, I believe the property owner has property rights. They are protected, and the fact that he has the 31 units, I hope if this doesn't pass tonight, he still builds that. But even as Mr. Stillwell presented, as he went down the 1, 2, 3 of what's there, number one, RV parks. Okay, well, again, RV parks, I've been to RV parks where there could be 1,000 of them, and when you look, you can't see one because they're all shrouded by vegetation. So it's not, I think, so much as what's there is how it appears to the surrounding area. Number 2 is conservation, and number 3 was residential. That was from Mr. Stillwell's testimony. So again, when I look at this proposed use of this land, I just don't see that as a compatible use of that property. I also find that the testimony, or what I would say, not the testimony, but the comments of the former fire professionals, I would consider competent evidence due to what they said their background was. I have no choice but to take them at their word of what they said. So, with all that said, again, you always want to work, but we keep coming back to a couple things. And finally, the request from REC and to CLC is changing from a less intense use in the coastal high hazard area to a much more intense commercial use, which, again, I think, and I think our code says should be discouraged in the coastal high hazard area. So for that reason, Mr. Chairman, I'm not going to vote in favor of this change. So.
Thank you. We honestly may need to look at the LDC again. It was changed back then, and I think there's a different viewpoint that's sitting up here today than then. But Mr. D'Amato, would you like to?
Thank you, Mr. Chairman. Thank you all for leaving your houses, coming here tonight, participating in Local Government 101, a dissertation in local civics, too. I voted in favor of the last unanimously approved proposal for this project. That was 31 two-bedroom cabins, a 3,000 square foot restaurant, a swimming pool, and a manager's residence. Proposed is a 110-unit hotel, a 2,500 square foot restaurant, and a swimming pool. That is a substantial increase in the density and intensity of development over what was previously approved. The current proposal is not compatible with the character of the adjacent land uses and the Homosassa and Old Homosassa communities. It is a more intensive commercial use in the coastal high hazard zone than previously approved. Public safety is definitely an issue per tonight's discussion. I also cannot support the application as presented.
Commissioner Meek, are you going to tell us you support this?
Yes, thank you, Chairman, for making me laugh.
Thank you, Commissioner Meek, thank you, too. And I was
Thank you.
just joking.
No, I know that. I know that.
Need to break the,
Well, thank you, Mr. Chairman. First of all, as all the other commissioners have done, I wanted to take this opportunity and to say thank you very much. I mean, what a showing that we've had tonight, and also and I think it's already been said, everyone has been very respectful and very civil, and we greatly appreciate that, to have that open dialogue and debate. And you're here not because you have to be here, but because you care about your community and your home. And so I really respect that, and I really thank you for doing that. Like a couple other people that are on this board, I was born and raised in Citrus County. This has been my home almost my entire life, with the exception of when I went to college. I grew up not in Homosassa, but I grew up on the Crystal River. So this is and I want to preface what I'm going to say here by saying this. I want to see progress in my home county. I want to see us grow. I want to see us do positive things. I want to see positive movement forward. And I think we have to recognize that some of the very communities that we live in now, they wouldn't be possible today, and we have to accept that. I mean, we look at areas around Crystal River. We look at River Haven. We look at those places that it was a different time. And so that progress has made us what we are today, but some of that progress has also been detrimental to our environment. And I think we have to recognize that. We love it. We're here. We're enjoying the very things that God has given us from that standpoint. We have to be cognizant of that. But we also have to learn from that, is what I'm trying to articulate. And learning from that, I think you will, at least sitting here and listening to the folks and listening to you all and what you're saying, I think hopefully we can make better decisions moving forward. I have a lot of respect for a lot of folks that spoke today, and Rodney McCray is one of those. I've known Mr. McCray and his family for a long time, and he did sum it up, and it's a compatibility issue. Commissioner D'Amato mentioned, and I did also vote to approve the cabin units. That was a different application. That's obvious. There are things where I think Mr. Schultz brought up with regards to, you know, if I'm coming here, which a lot of people do with my family, I'm coming to scallop and enjoy the Homosassa. I'm bringing my boat with me, and I'm going to put my boat in, and I'm going to put it somewhere, and you just can't do it on this application. And so that's going to arise with a lot of different issues. And so the other one you can, by the way, the other one has boat parking, you had a boat ramp, you had other issues, and that's a whole other discussion. It boils down to this: I don't believe the application in front of us is compatible with the area. I don't believe it's compatible with the things that we're seeking. As Commissioner Carnahan said, I would really wish that a project like this, I could think of a lot of areas that Citrus County needs this project in, and that I hope that projects like it go in those areas. But I do not believe the compatibility is there for this area, and I don't support the application. Thank you.
That means you're buying us all dinner for staying till 8 o'clock, right?
That's right. I was going to say, don't ruin a gifted thing here, y'all. Okay. I want to thank the two firemen to bring forward and the professionalism that they brought, and even there's a lot of things that this county today is going through with fire. And remember, with growth, it costs money. And this gentleman, the fireman, said, hey, a water line may cost $2 million. Ladies and gentlemen, remember, it's how quick we grow this county is how expensive it's going to be to live here. And I think everybody said why they live here. There's a quality of life here. And there's a number of things. But I want to thank Mr. Stillwell. Are you still here, Mr. Stillwell?
Mr. Chair.
Ma'am?
Mr. Chair.
Yes.
If I might, we've got the court reporter, so you might want to talk a little slower.
Okay. Mr. Stillwell, I wanted to actually thank him because, you know, he shows up even when it's by himself representing somebody with a crowd like this, and you got to give the guy credit. So we thank everybody. I'm going to call the vote.
There's not, is there a motion? I don't believe there's a motion, Mr. Chair.
Do we have a motion on the floor to, or we don't even need to?
But we need a motion, yes, sir.
Yeah. Do we have a motion to deny?
I make a motion that we deny this permit as presented.
All right. I second the motion.
Is that an adequate motion?
I would say it needs to deny the application.
We need to, I amend that, and we need to make a motion that we deny the application.
And I second that motion. So we've got a motion and a second. Is there any further board discussion? If there's no further board discussion, all those who oppose, all those
in favor.
favor, aye. It's a unanimous vote to oppose the.
Approve the motion.
Okay, we're done, man.
Mr. Chair. Mr.
Hang
Chair.
Whoa, hold it.
Mr. Chair,
Yes.
may we have some clarification, please? That was a unanimous vote in favor of the motion, which was to deny the application.
Yes, correct.
Correct. Thank you.
Okay, thank you.
You're still in your meeting, so you need to adjourn
All
your
right,
meeting.
we're going to recess for 5 minutes, ladies and gentlemen, or say,
I think we don't have anything else.
well, Dennis wanted to take a break. Dennis.
I don't think there's anything else we need to do.
Meeting,
Mr. Chair, I make a motion we adjourn.
Second.
okay, meetings are, all right, yeah. Well, Dennis took off.